Before you hit send on another snarky email, before you pick up the phone for another meet and confer or file a motion to compel, there's a smarter way to do discovery. I'm attorney Rob Schenk. This is the Justice for Residents podcast, and this week I am joined by retired trial lawyer Mark Kosieradzki, who will break down the Rule 30b-6 foundational deposition and how it helps lawyers get ahead of objections and all the malarkey early in nursing home litigation. Stick around. Okay, I definitely this was a good jingle. That's baby making music in terms of podcast jingles, nursing home podcast jingles. I dig that. Good job, Gene. Thumbs up. This week, folks, fantastic episode. I have a wonderful conversation with Mark Kosieradzki, tremendous trial lawyer, prolific author, as we'll get into in a second, about foundational depositions at the beginning of a case in order to better conduct discovery and get the documents that you need. I have been a fan of Mark Kosieradzki for many years. I have all of his books that he has done, and we'll talk about some of the new additions to old books and new books coming out and the methods contained within them. I actually have them. Usually they're over my shoulder. Let me get it for you. This is the one that's helped me probably the most. This is his 30b-6 deposition book, which again, as we'll discuss, there's a new edition coming out, and I highly recommend everybody check that out. In terms of homework for this episode, other than reading all of his books, I would say go back all the way back almost 10 years to episodes 57 and 58, where I talked to Mark previously. These are 2018. I think February, March of 2018 is when we had him on. This actually, I want to say that Mark was one of the first guests that we had on the show. Of course, Richard Mollett had to have been the first guest. I mean, this guy, Richard Mollett, come on. But other than Richard, I think that Mark was one of the first guests that we ever had on the show. I emailed him and he was gung-ho about it. And so we're super happy about that. But at any rate, if you want to hear Mark talk about his work fighting abuse in nursing homes, episodes 57 and 58. And he actually has a really cool anecdote, I want to say, in episode 57, where he discusses how in a deposition, he had an administrator or maybe someone from the corporate office admits that particular nursing home would spend more, they spent as much on food per day in that nursing home as like a can of dog food or something. He was able to make a very damaging analogy in that particular case, but that was a really cool episode with him. But not to say this episode is not great. This episode is fantastic. All right, but now it's time to get to the hamburger and french fries of the episode. Mark Kosieradzki is a nationally recognized trial lawyer and author known for his work on Rule 30b-6 corporate depositions and discovery strategy. He has taught lawyers across the country how to use corporate testimony to uncover key documents, lock in admissions, and build stronger cases from the very start of litigation. So, Mark, I think that the audience understands the concept of taking a 30b-6 deposition for the purposes of trying to understand what documents perhaps exist, getting ahead of objections. But tell me why that even framing it that way might be outdated. How has your system evolved?
Well, when we first, this whole process started, Rob, when I came to recognize that written discovery is pretty much worthless. I'm sure you've experienced, and our listeners are experiencing, that anytime you do a written request, be it an interrogatory or request for admissions, a document request, our adversaries seem to feel that it is their role to obstruct that. And they object to everything. And then you get into this big fight about, is the objection valid? But we have no evidence to prove that it's valid or not valid. It's just our are words.
And oftentimes their word too, because I feel like they're not bringing affidavits or witnesses themselves to the motion to compel hearings. It's just like, well, Your Honor, we think this. So it's kind of,
It,
yeah.
it's an I said, he said. And, one of the things we learn in law school is to say, I would argue. And, I could care less about what the argument is. I want to know what the judges say. I want to know what the law is. So what happened is we developed this system of thinking about what the objections are before they're made, and so we use 30b-6 as a tool to identify what documents are out there and what those objections might be before we even make the request. So it's a little bit different than a lot of people think, because in the old days, the document deputy would say we'd have them bring the documents and verify that those are all the correct documents. Well, I don't know, it was probably around, I don't know, 2018 maybe. It's the whole concept of discovery about discovery surfaced, because the courts are pretty clear. You can't ask someone about how they conducted their response to discovery unless you can prove or show that the stuff is false. But now you're 2 or 3 steps down the road and a year into the litigation. Um, so rather than taking a deposition and asking people to bring the documents and authenticate them, we've come up with the concept of the foundation depot, which goes to my latest book, Litigation Obstruction, chapter 15. And what the whole concept is, you've got documents you want, because the truth is in the documents. And what we need to do is get those documents. And so we got to figure out, what is the adversary going to do to try to prevent us from getting the information? So we start with crafting the notice, crafting the request for production. And I think we have to really think real carefully about it, about why are we asking for something. If we just say, well, Taj had it on the listserv,
Mm.
or I got Chat GPT told me this was a good request, that's not going to cut it. So you got to think real carefully. What is it that I want, and why do I want it? Because relevance is the starting point always. Is it relevant? And relevant really has to be the ability to tell a judge why this helps prove something that's important in the case. So we start with that, and we work really hard at drafting the document request. And I'll just sit and I'll think, okay, what is it? Why do I want this? And if I say, well, maybe in 1 in a million times or 1 in 2,000 times I'll catch some line, probably not. That's not good enough. We got to say, this particular document or electronically stored information is going to help prove an element of the case or neutralize a defense in the case. So put it up, type it up, put that request for production up on the board, and then call in your friends, colleagues, and say, how would you try to weasel out of this? Is it you know what I'm talking about? What are the objections they're going to make?
Mm-hmm.
And then say, okay, are those objections valid? If I say, give me each and every email that you guys have ever written in the last 10 years, overbroad. So we think about all the objections, starting with, is it relevant? Is it overbroad? Is it vague? How precise it is? All of these things. And, in the book here, you know, I identify all the objections in the law about it that you already know what they are. Someone says, gosh, I don't know what their objections are going to be. It's nonsense. They're going to vague, overbroad, immaterial, irrelevant, violates the rule against perpetuities. The information is stored in a space capsule on Mars, or a unicorn peed on the document and destroyed. I mean, it's just junk, but you know what it's going to be. So think about this documents, why you want them and what the objections will be. Then we take the document deposition before we serve it. We don't serve the request. So this is the important part to remember. What we want to do is we want to identify what documents are out there, what is the most proportional way to get them, and then neutralize the objections. So then, when you do this document request or this foundation deposition, where you take the RFP, the request for production that you have not served, copy it and embed it, those exact terms into your notice. And you've got it on your back shelf. I can see it on your book there.
Of course.
And and so now you can have these matters of examination where you ask them to tell us what documents exist in this category of documents, in this title. And we're not asking you to give them to us, but if I ask for a personnel file, what's in that file? Well, I've learned taking too many of these that personnel file is not a good term. You want a human resources file. And because there's all kinds of things that they put into a different file, like discipline reports. That goes in the discipline report file that is part of the human resource file. So you got to kind of know what you're looking for and say, okay, if I use the term human resource file, what does that mean to the organization? And they say, blah, blah, blah. Well, what documents, what categories of documents are in there? Blah, 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 blah. And that you know what you're looking for, and you're looking for the performance reviews. So, well, are performance reviews in there? Well, no, they're in a different file. Okay, what's that file called? What you're doing is you're identifying, what are the things that are supposed to be in that request before you've made it. So that's, the starting point. And then so the next thing is, what is the purpose of having these documents? And the reason the purpose is important is it'll go to show relevance, because it's how it's used in day-to-day activities. And there's a couple of other steps in there. For example, how are these documents disseminated to other people? Does anyone get to see them? And then through that, you say, well, are there things, to make sure that they're not shared with anybody? Because that helps neutralize the confidentiality. But then we get into the important part. It says, where are these documents stored? Are they stored in different places? And what is the easiest, or what are all the different ways to retrieve those documents, and what are the easiest ways? And I think the classic example of that is the emails, because you're always going to say, oh, well, we have a system that destroys the emails, purges them every 30 days, because the server can't hold them all. Okay, well, do they go anywhere? Well, yeah, they go into an archive file. What's an archive file? A full server. The archive service stores all the emails that have been deleted. How long are they held? 7 years or 10 years or indefinitely. How do you search that? Well, we have a software that searches it. See, you're identifying all these things. And when you're back at the beginning talking about, what are these documents? Say, what does that term mean to the organization? Is there anything vague about that term? How is it used in the ordinary course of business? You're getting rid of vague. You're getting rid of overburdensome. You're getting rid of where they're stored. And what you've done is you've identified all the responses to every objection, and you've identified every document that you can get.
So let me be old cause for a second.
Okay.
Okay. So let's say that it's 2021. I why would you now not want to do this way? I go ahead and send the request to produce, okay? Only before I take this deposition,
Right.
but only so that I know what objections are being made. Now, I know that you said like we already know. Sometimes like they surprise me. Okay, like sometimes there are objections like how are you going to object that this is privileged but also public available, right? So like at least that is a way where I can reduce the amount of time I actually spend at the 30B6 deposition. Because if I've got to go through the vague questioning for all maybe 50 or 60 categories, that might be 2 hours when I might only need to do it on 5 of them because those are the ones they actually made the objection on. Now tell me like why do you think that might not be a good way to do it anymore?
Because then now you have to go into discovery about discovery. You know,
Okay.
if they say it's overburdensome, well, now they said they've already said it's overburdensome, and we have to take their word for it. Because now we're taking discovery about what their responses are, and we can't conduct responses about or discovery about what their responses are because of the discovery on discovery.
We interrupt this interview for the nursing home regulation question of the week. This week, folks, I think that the difficulty level is hard. Like, this is not necessarily an easy one like they normally are. So, if you get this right, instead of going to McDonald's, you get to go to Five Guys. Under 42 CFR 483.80b, the infection preventionist is required to A, provide consulting on a regular basis, B, work at least part-time at the facility, or C, work full-time at the facility. And that answer is B. The nursing home's infection preventionist needs to work at least part-time at the facility. So enjoy your Five Guys and your $65 bill. I guess then that means that I'm ignorant of the objection regarding discovery on discovery,
Yeah,
because I feel like I'm like at least to the Georgia bar, I'm still like if they have objected to something being, let's say, privileged.
yeah.
Even though I'm not doing a foundational like you are, I find out okay they've made the objection on incident reports as being quappy privileged. Okay, I'm still going to go in on the cause line of questioning of like okay how are these created? Who has access to them? Are they used from shift to shift to keep providing care? And I really haven't had a pushback on well Rob because we've already told you that it's quasi privileged now you're conducting discovery on discovery. I guess that hasn't been a problem for me right now.
I've had multiple cases in Georgia, and I did face that.
Oh no.
It depends what
Your
lawyer.
fame precedes you apparently.
Well, it's but the long and the short of it is, you say it's going to take you longer. It's not going to take you longer. It's going to be much shorter because you're going to have to do all the meet and confers and everything and build the record anywhere. And there really aren't that many objections they're going to surprise you with because you're going to deal with privilege, you're going to deal with vague, you're going to deal with overburdensome, you're going to deal with work product, you're going to deal with all of that stuff in the process based or in the foundation depot.
Mm.
And because then we go on to the next step because we have this spreadsheet method. You've taken the deposition. You haven't asked for anything, so they can't object.
Mm.
they will, but there's really, they can't object because you're not asking them for anything. And your response is, well, I just don't want to ask for anything that doesn't exist. I
Right.
would, and I want to find the most proportional way to get it. Now, granted, is if I recall correctly, Georgia doesn't have proportionality in state court; they do in federal court. But you have overburdensome in Georgia.
That is true.
Yeah, which is the judges look for the same stuff. Okay,
Hmm.
but when you're coming, if you're doing it from the beginning here, they haven't had the time to really prepare for all of this stuff because a lot of the defense lawyers just respond to whatever you're doing. They learn the case through you. It's crazy. Um, so if you take this deposition right at the beginning and you really take the time to craft the notice, now you set up the spreadsheet, okay? And that's in the book, you know.
Hmm.
There's actually a software if you want also to make it even easier for you. And the way it works is the first column of the spreadsheet is your individual request, which means it's got to be tight. It's not like 4 paragraphs long. I want this document. The next column is relevance. Why do you want it? And I recommend creating the spreadsheet before you even make the request. Okay. Um, because when you get down to why you want it, if you can't say it in 1, 2 sentences maximum, there may be some problems with it. And so you set this up. So you got whatever it is, the 10 requests, the 20 requests. I'm finding that as I got in my career, I started asking for fewer documents because I didn't need them all. And there was a lot of fighting and pushback about it. So I was really focusing on what I needed and why it's relevant. Okay. So you set that up well in advance. If you're a young guy like you can even export that right into your document request and you build it in the spreadsheet. So now you've got that, okay? The next column is each objection they're going to make for each request. And there'll be a separate line for each objection. And there's always going to be 7 to 12 objections. And like this, the spreadsheet system I have set up will, and by the way, I developed this in Georgia.
Oh, great. All
Uh,
right.
and it was because I was getting so many stupid objections. you
That's how
know,
we do. That's how we do in the Peach State.
yeah, well, but so then what happens is for each request, you've got 1, 2, 3, 4, 12 objections. Request two, 12 objections. And you'll see that they're the same objections over and over and over and over again. The next column is just a 1 sentence, what's wrong with the objection procedurally. Like vague, well, if they object vague, they're supposed to contact you before the 30 days are out to clarify it. And if they don't, there's a problem with that. Or overburdensome. They can't just say it's overburdensome, they have to say why it's overburdensome. And so when I wrote litigation obstructions, I literally dug into all the jurisprudence for all the law for everything. Or they say confidential, but they don't say why it's confidential. Or they say privilege and they say, but they don't give you a privilege log, which they do all the time. Even though the law is uniform that you have to do a privilege log when you assert privilege. So now you've got the request, the relevance, the objections, and the procedural problem with each objection. Next column is what's factually wrong with the objections. And that's what your 30B6 depo is for, the foundation depo, because you ask, when you read the request right into the records, what does that term mean to this organization? Blah, 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 blah. Is there anything vague about that? No. Okay. Copy and paste, drop that into this spreadsheet. And this is sounding like a lot of work, but it's probably an 3, 4 hours work versus 40 hours of meet and confer emails that go on endlessly and you can't keep track of them. So now you got what's wrong with the objection, what's wrong with it, and factually, and boilerplate objections are de facto, improper. In Georgia, unfortunately, it doesn't have 26G unless it's happened recently, but the federal courts do, where it's the attorney has to certify, like Rule 11, that the objections are valid.
Mm.
But most judges kind of take that same approach. That they'll say, well, what you're making objections without a valid basis for it.
Mm.
So then the final columns are withdrawn, sustained, and overruled. And now once you've embedded this, and you're going to get these objections, because what happens is you've taken the depo, then you serve the request. Okay. 30 days later, you get the response with all the objections. Your spreadsheet is set up. You just fill it out. And if you use the software, all you do is click the buttons and it'll fill in the objection and the procedural problem with it. And then you finish it off. So then the idea is now you send the spreadsheet to the defense lawyer and say, this is a template for our meet and confer on everything. And of course, it's well recognized that boilerplate objections are improper and in some courts de facto sanctionable. And respectfully, some of these look like boilerplates. So before we even spend time on the meet and confer, take a look and see which ones you want to stand by. Well, now you've already got the facts in there saying, what's wrong with them. And I mean, so you've now spent an afternoon on a 30B6 a depo and an afternoon on the spreadsheet, and you don't have 40 emails. And you said, let's get together. And Render Freeman down there in Georgia taught me that. He said, let's get together for coffee.
Mm.
That looks
Yeah.
great in the motion, And you just say, check these things off. What objections are you standing by? And factually, what is the basis for them? Well, all of a sudden, you've neutralized all of those objections before they've even happened. And, I had one woman in North Carolina use this. She went from 308 objections to 4 because
Yeah.
it all jumped off the page. And the meet and confer was a 1 hour coffee, and the filling out the form was maybe 3 hours, and it was done. And
But
the beauty of it is you can show the judge that there were 300 objections and you resolved 301 of them. And the judge says, wow, you guys are professionals. It's an honor to work with you.
and I was going to say what's really cool is that with the spreadsheet is basically the judge has it in front of him or her, and it's just all the judge has to do is go boom, and you've got your order, right?
And here's the beauty, because in the book, we also have the template brief. I mean, you got to tweak it, but instead of having a 40-page brief, you have an 8-page brief. That you just have each type of objection, 2 paragraphs on the law. They don't want a tome. Say, objection, overburdensome. Here's the law on overburdensome. Counsel or defendant has asserted overburdensome to interrogatory 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10. Every one of them.
Yeah.
See the spreadsheet. So they got the spreadsheet where it's all the factual and legal, and then you got a short brief that just shows what the law is, so the judge can copy and paste that into the order.
I've been using, I call it your method. I mean, I don't know, but I've been doing what you have described, not this newest one, but the previous iteration for so long now. And I can't tell you how many orders that I've got for documents that in my favor that I wouldn't have gotten it otherwise because I've built the record.
Yeah.
And it's just, and it's funny because it's like, you say this and it sounds like common sense, like what, but you know, for a long time I didn't do that. I didn't. I'm going, Your Honor, personnel files I should get because of X, Y, and Z. Well, I don't. I'm rolling the dice. But when I have a record of the administrator saying this is exactly what's in them, we have resignation letters. Sometimes when they're pissed off, we put that stuff in there and blah blah blah. The judge has no other option than to go, yeah, it is relevant, and et cetera, et cetera. So yeah, it is an excellent system for nursing home cases because nursing home cases are document intensive. Tell me, tell me in the last few minutes that we have here, what are some of the things that we can look forward to in the new edition of your 30B6 book?
Well, the 30B6 book is very similar to the second edition. And the only reason I wrote the third edition is second edition was in response to the attempted rule changes, and that didn't happen. So I showed how all the things that they had been arguing were rejected by the Rules Committee, which pretty much neutralized a lot of those objections and obstructionist moves that we still need to use the spreadsheet method to identify, but it neutralized it. But what happened was then, okay, if we can't do that, then we're going to try to prevent the evidence from coming into evidence at trial. And all kinds of nonsense occurred about trying to block 30B6 testimony at trial. And a whole area of jurisprudence evolved on it between the second and third edition. So the last chapter of the book is completely new, and it's all about the rules about what you can and cannot do for introducing 30B6 testimony. Can they do it? You know, can you call the witness live? Non-party versus party, and so that's all new. So it's, if you're going to trial and you plan on using 30B6, it's a must. The
And what's interesting to me on this edition is that like it it's it can be super confusing sometimes to conceptualize these things. Like, okay, like we have this corporate depot transcript that we want to read, but that person's here, or it's a different designee now. Like who, you know what I mean? Like there's just it's so many different ways that it can be approached. That's good that we've got this jurisprudence in one location.
It's all there. I'm going to tell you, the chapter is only like 20 pages long, but it took 6 months to write it, to just to parse out all these nuances. And I worked pretty hard to try to make the books accessible to people because, these are abstract concepts.
Mm-hmm.
The other part of the book that's new is I updated all of the appendices to make sure we had the most recent state jurisprudence about the 30B6, which is almost non-existent. It's making sure that we know what laws the state has, the language, and how the state Supreme Court looks to federal authority. A couple of states have cases on them, but not many. But
How does it feel like, and I wanted to ask you this, how does it feel reading in the past 5 or 6 years all these district opinions, all the appellate opinions about 30B6 that exist only because of attorneys that have read your book? You know what I mean? Like you're one of your legacies. I'm sure you have kids and grandkids and all that. One of your legacies is all these opinions based on the work that you did in 30B6.
But it's fun because oftentimes I'm pretty honored to see the exact language from my book in the case. That doesn't cite me, but the language is there. But I mean, the legacy is actually a big part of what this is my daughter just said, Dad, you spent 45 years just fighting, and you've got all of this knowledge and these techniques and things that you develop, and you should share them with people. And so the most important thing for me is empowering lawyers to stand up to bullies, because I hate bullies. I was bullied as a child. I was bullied as a young lawyer, and people tried to continue to bully me to the end, but eventually it got to the point where they couldn't do it because I knew the law. And if you know the law, You don't have to sit and go home at night worrying, well, did I screw up or not? You know that you did it right. And so if you know the law, and I've captured it for you as a legacy to empower new lawyers, older lawyers to stand up to bullies, and in some cases, even teach the bullies how to not get in trouble by not bullying. And I have defense lawyers contact me and say, Kos, I'd like you to just go over this and tell me, am I doing this right? Because I don't want to get sanctioned.
Very well said. Well, I am definitely one of those who have been empowered, if I may say. So I really appreciate the work that you've done. And Mark, again, I really appreciate you coming on the show and sharing your knowledge with us.
Well, it's been a privilege and an honor. But as you know, which I always say this, no matter what it is in life you're encountering, you can count on one thing. It always goes back to the blues. So there we go.
That was amazing. Thank you so much, Mark. Folks, I cannot recommend Mark's books enough to get. I have all of them. So like you've got the 30B6. To me, that's the OG. I recommend that. Deposition of Obstruction is also an excellent book. I don't think we discussed that in his interview, but Deposition of Obstruction is really great. He goes through basically whether or not objections and depositions are valid or not. And this was very helpful for me, particularly as a younger lawyer. And then, of course, as we just talked about, litigation obstruction. I'm not getting any money. I'm not an affiliate. I'm not anything. I'm just a huge fan. So I'm not selling anything, but these books are fantastic. The litigation obstruction is the one that we discussed most today. That's the one where it has a spreadsheet and stuff in it. Folks, if you enjoyed the content of this episode, please be sure to like and subscribe wherever you get your podcast from. If you have an idea for a topic that you would like for me to talk about, let me know. If you have an idea for a guest that you would like for me to talk to, let me know that as well. New episodes of the Justice for Residents podcast come out every single Monday. And with that, folks, we'll see you next time. Thanks for tuning in to the Justice for Residents podcast. Nothing said on this podcast, either by the host or the guest, should be construed as legal or medical advice, nor is intended to create an attorney-client relationship between the listener and either the host or any guest. New episodes are published every Monday and are available on all your favorite podcast apps, as well as on YouTube and our website, justiceforresidents.com. Again, that's justiceforresidents.com. The Justice for Residents podcast is hosted by Rob Schenk, a trial lawyer representing victims of nursing home abuse and neglect throughout the state of Georgia. We'll see you next Monday.